Okay, thank you, Eric. As Eric mentioned, I am Andy Frey, a Vice President with Cutler Investment Group. Thank you for joining me today as I go over some estate planning essentials and discuss why it should matter to all of you. Today's presentation will be available on our website after we conclude the discussion. And if you have questions, please feel free to use the chat function or reach out to me directly or to your advisor at any time after today's presentation. First things first, I am not an attorney, nor do we maintain an estate attorney on staff at Cutler. However, we are more than happy to provide recommendations of qualified attorneys that we know. So for the purposes of today's presentation, the information, analysis, and opinions expressed herein are for general and educational purposes only. Nothing contained in this presentation is intended to constitute legal, regulatory, tax, accounting, securities, or investment advice, nor an opinion regarding the appropriateness of any investment, nor a solicitation of any type. Information obtained from third-party resources is believed to be reliable but not guaranteed. All opinions and views constitute our judgments as of the date of writing and are subject to change at any time without notice. And now that we have that out of the way, why are you here? Today we're going to talk about death and taxes, and frankly, who wants to talk about either of these subjects? As you'll see from the cartoon, we have death sitting across the desk from an IRS agent discussing the inevitability, and that's exactly what this is all about. Overcoming your own mortality and knowing that you can maintain control of your life and assets while creating a plan. You're thinking, great, what is this going to cost me? Now I have to go hire an attorney. But one of my favorite expressions is fees only exist in the absence of value. This isn't about you. It's about your family. It's about those that you leave behind and love. So recognize it as such. You don't want someone else making these decisions for you or your family fighting over your estate after you are gone. And lastly, why does this matter to us here at Cutler? We are your wealth advisor. Think of us as your financial quarterback, if you will. We want to help you identify what's important and work with your estate attorney to make sure that you're receiving the best advice and support that's in your best interest. We want to help you safeguard your meaningful legacy for you and your loved ones. So what is estate planning? I just want to take a minute to go over this very broad topic, and then we'll go into some more specific details. But if you own anything, then you have an estate. This isn't something that's just for the rich. It's for anyone. It's for all of us. And basically, if something were to happen to you, it's your way to express what you would want to happen if you become incapacitated. Who gets what and when. So it's very important, especially if you leave behind minors, children that are minors, or complicated family, business, or real estate situations. What it really boils down to is organizing your personal and financial affairs to plan in advance to ensure that your estate passes to those that you choose while minimizing your taxes and legal fees. As I was working through some of the material for this presentation, I came across a great quote from Wendy Witt, who is an estate attorney and the founder of AMillionFamilies.org. It's her mission to help as many individuals as she can. She says everyone needs an estate plan because it is simply about control and protecting the ones that you love. So again, what if something happens to you? Are you concerned about your heirs, your children, your beneficiaries, and those that will inherit the assets that you've earned over your lifetime? So it comes down to simplifying that probate process, preventing it from being handled by a court appointee, and allowing you to ensure that your instructions are carried out as you desire. So minimizing your estate tax burden, avoiding a mess before it's too late, protecting your beneficiaries and assets are many common reasons and some concerns that I have heard from parents previously, particularly about their children. They have too much emphasis on material things. They're naive about the value of money. They spend beyond their means. Their motivation could be ruined by affluence. They simply just have a hard time taking financial responsibility for themselves. So there's a lot of reasons that that could be the case. Kiplinger estimates that 64% of Americans do not have a will or estate plan in place. It's too overwhelming. I have plenty of time. There are a lot of excuses why you wouldn't do this, but it's very important to get it done. So hopefully today's discussion might provide some motivation for that first step or an update to an existing plan. So All estate plans are going to be somewhat different, personalized to you, and there's a lot of ways to go about it, but I want to cover some basic components of estate plan essentials, starting with the last will and testament and possibly a trust. This will be the core of any estate plan. And a will is a legal document outlining how and when your property is to be distributed after your death. In it, you'll name a personal representative, your executor, for your estate, and it can contain other directives such as, should the assets be placed into a trust? Are there minors that need to be appointed a guardian or trustee? Are there any outstanding debt, tax, or other issues that need to be settled? There should be instructions for that. And again, important to note that there's several ways to do this. A value-add attorney will help you create a plan that's specific for you. But it's important to know that the more buttoned up your will and or trust, the smoother the probate process will be. Additionally, a durable power of attorney, this is to allow someone to step in and manage your affairs in the event of incapacitation, and an advanced medical directive, also known as a living will. This will lay out end-of-life decisions such as a do not resuscitate order. So I mentioned that dirty P word a couple times previously. That is probate. I found a great, concise definition for what probate does, what it is. Probate is a court-supervised process that's required when someone dies, leaving a will, and even if he or she does not leave a will. His or her estate must pass to his or her heirs and beneficiaries, and probate is the legal process by which this is accomplished. Right, so this is what happens when you die and your estate must be settled. That probate comes into play. Ideally, as I mentioned previously, you've already named that executor of your estate to simplify the process. But it's important to know that in any state in which you own assets, in which you have property, you will likely be subject to probate, and it does vary in terms of complexity and duration, time of duration in terms to get through that probate process. Next, probate is very much a public matter, right? So once the court has begun the probate process, the public is available to see those records. This is an opportunity for people to contest the will. This is when long-lost family members might come out of the woodwork trying to make a claim, and creditors can submit claims for payments. So it's very much a public matter once it's in the court's hands. You may have several types of property or assets that are not subject to probate, and I want to run through a list of those, what some of those might be. First would be property owned as joint tenants with rights of survivorship. This could be a brokerage account that you and your spouse own. If you were to pass away, then your spouse inherits the entire account as a joint tenant of that account. Property subject to a beneficiary designation, things like IRAs, 401ks, annuities, and life insurance plans, where they all have a stated beneficiary as part of that. Property with a transfer on death designation. This might be a bank account in your name, and perhaps your spouse is listed as the transfer on death beneficiary. Property subject to a community property agreement. That's worth noting, since we have many clients in Washington and California, that those are both community property states. However, if you're in a state that is not community property, you can establish that agreement in those states to ensure that many of the assets inside of there pass along to your spouse as community property. And lastly, property held in a revocable living trust. And this is what we will discuss next. So a revocable living trust is a legal entity created to hold the ownership of your assets. And while you are alive, the revocable trust generally remains under your control, and the assets remain yours. So you can be the grantor, you can be the trustee, and you can be the beneficiary, all rolled into one. And the key word here is revocable. You can take it back, you can change it, you can modify it, you control it. So the money remains yours. You do not get a separate taxpayer identification number for the trust. The assets remain in your control. A successor trustee should be named in that revocable living trust document, someone to take over management of your affairs if you become incapacitated or pass away. And this becomes irrevocable upon death. And that's when that successor trustee again steps in to pay final bills, taxes, and distribute the remaining assets to trust beneficiaries according to the trust documents. So we've talked both about wills and revocable living trusts, I just want to highlight some differences. A will may be sufficient for many people to handle their estate needs, and a revocable living trust may be part of that plan as well. A revocable living trust does not require probate. And this is a good thing when you have complex situations. And a great example may be, let's say that you own property in multiple states. You are a resident of Washington and you have your main home there, and then you have a beach home in California and your condo in Manhattan. If you were to pass away and those assets are not inside of a trust, you will be subject to probate in every state in which you own that property, making it a lengthy process. Additionally, revocable living trusts remain private. So no probate means not open to the court of public opinion. If privacy is something that's important to you and your family, a revocable living trust can handle that. However, they are typically more expensive and time-consuming, right? So the upfront costs to establish the trust are typically higher, and it can be time-intensive to move the assets from individual accounts or accounts in your name into the name of the trust. A will is typically used to name a guardian for minor children. However, a trust can supplement that by creating additional planning stipulations. And a great example here might be parents that are divorcing. If they have children, a trust can be established to name the children as beneficiaries and create stipulations for how the assets are to be handled while the children are minors and even on later into life as well. And lastly, a pour-over will. If you have a trust, you will likely have one of these anyways. A pour-over will is in place to encapsulate anything that has not made it into the trust. Let's say that you have established a trust and years later you go create a new bank account and you forget to put it into the name of the trust and you die. A pour-over will make sure that that trust is handled as smoothly as possible via probate, as again, all the assets, or most of the assets, I should say, not inside of that trust will be subject to probate. So we've talked about revocable trusts. I want to switch gears just a little bit and talk about irrevocable trusts. Keyword again here, irrevocable. These cannot be revoked, they cannot be changed, they cannot be modified. Once you put the money into it, it no longer belongs to you. There are two general types of irrevocable trusts: an irrevocable living trust and a testamentary trust. With an irrevocable living trust, you create it while you are still alive, and therefore it's going to bypass probate. The trust entity will own the property. You cede control of the assets after creation and funding, so you can't be the trustee. You no longer own the assets. One of the cool parts about this is you get to give it away now, and you get to see the benefits of whom you give it to and what you give to them. The second type is a testamentary trust. This is one that will be created upon your death. So the language is going to be laid out in your last will and testament, and it becomes irrevocable upon death. So thereby it does not bypass probate, because that is the process used to put the assets inside the trust. However, this does allow you continued control beyond the grave, in that the trust language that you've created prior to your death will control how the assets are distributed and used long after you are gone. So why use an irrevocable trust? I mentioned previously that revocable trusts, the assets still remain yours while you were alive, still subject to creditors, taxes, etc. With an irrevocable trust, you can get creditor protection. You no longer own the assets, your trust does. A second reason would be for estate tax reduction. Property you've already put into an irrevocable trust does not contribute to the gross value of your estate. Since we do have clients in many states, I'm going to focus just on the federal level for this topic here. Estates with a value above $5.49 million in 2017 are subject to the federal estate tax of 40%, so pretty high tax rate there. However, federal law does allow for portability, which is the process whereby the exemption of the first deceased spouse is passed to the surviving spouse. Thereby, a couple then, in all practicality, has an exemption of up to $10.98 million before that 40% tax kicks in. Putting assets into an irrevocable trust, again, reduces the taxable value of your estate, so this becomes crucially important if your estate is above that $10.98 million at the federal level. Third reason, again, is asset protection and control, creating benefits and protection for your surviving spouse, avoiding guardianship issues for minors, talking about irresponsibility. Perhaps your children, your beneficiaries have addiction issues, substance abuse issues, or simply a lack of self-control with spending. A spendthrift trust can handle this. If you have children with special needs, you can protect them and their ability to earn government benefits. Or if you just have another idea in mind, a certain use for where you want to see your assets go, there's a good chance an attorney can help you create the stipulations around that. So I do want to spend a few minutes now talking about some various types of irrevocable trust that we have encountered. And this may seem like a lot of detail, but the purpose is to arm you with enough introductory knowledge to begin to understand what situations might apply to you and where to go when you do take that first step of meeting with an estate attorney if you have not already done so. Remember that there are dozens and dozens of types of trusts out there. These are a few that may or may not apply to your situation. The first group is typically focused on reducing taxability, but also does provide some control, whereas the second group I'll discuss is more focused on control, but again, does allow the ability to reduce estate taxes if necessary. A bypass trust is about reducing estate taxes when the second spouse dies. So again, you can pass assets to your spouse via the marital deduction, that portability issue we talked about at the federal level. But when the second spouse dies, now their estate is significantly larger. But if you pass it on via a bypass trust, those assets do not belong to the surviving spouse, they belong to the trust. So you've already reduced the amount of their taxable estate. Again, very important if you're going to be above that federal exemption mark, and particularly important to our clients that live in Oregon and Washington. California does not have a state estate tax. Oregon has a state estate tax with only a $1 million exemption. The state of Washington in 2017 has a $2.129 million exemption. So again, at the state level, assets above and beyond those numbers will be taxed in a state tax rate. Next would be a charitable remainder trust, and this is about estate reduction through giving and providing income. So you are going to reduce the value of your estate by naming a charity as the beneficiary and simultaneously naming someone like a spouse or a child as an income beneficiary to receive income payments from the trust for a set period of time. Third would be a generation skipping trust, and this does exactly what it sounds like it does. The most common use would be your grandkids as your beneficiaries, but in practicality, it doesn't have to be your grandkids. It has to be someone at least 37 and a half years younger than you. And so a typical structure might be you give the assets to the grandkids in the trust, and you provide your kids, their parents, with income from the trust. And the whole purpose of this is to avoid double taxation. Let's say that you pass all of this along to your children and estate taxes were owed. And then when they go to pass along the assets to their children, estate taxes are owed again. By doing the generation skipping strategy here, you pay a one-time generation skipping tax. Again, it has the same federal estate exemption level, and you just pay the one-time tax. Next would be a life insurance trust, and this is where you would put the proceeds from life insurance policies into a trust. Recall that life insurance is not subject to probate. You directly name your beneficiary. However, it's about reducing the value of your taxable estate and additionally creating stipulations, protection, control over how that death benefit can be used by your beneficiary after you are gone. Last would be a grantor retained interest trust, known shorthand as a GRIT or a GRAT. It's about removing property from your estate, but you keeping an interest yourself. So you name another beneficiary in the estate, in the trust, and you can name yourself as an income recipient for a set period of time from that trust. The next group of trusts we'll discuss are really about protecting property, creating that protection beyond the grave with the addition of having estate tax benefits as well. A qualified terminable interest property trust, or a QTIP. This is, again, a great strategy to reduce taxes, provide income, control funds, and a perfect example of when this can be utilized is, let's say that you have remarried, and from your first marriage, you have a couple of children. you would want your children to be the ultimate beneficiaries of your assets. And so you can create a trust that names them as the beneficiaries, but provides your new spouse, your second spouse, with lifelong income after you are gone. So protecting not only your children, but your second spouse as well. A spendthrift trust. This is what I was talking about earlier with those that maybe have an inability to manage the money on their own. Again, it could be due to substance abuse, addiction, lack of self-control. You can create stipulations for then how the money can be spent and accessed after you are gone. I've heard of drug testing being part of that, employment requirements, or simply just calendar periods when they're allowed to access funds from the trust. Lastly, a special needs trust. If you have beneficiaries that do have special needs, sheltering the assets in a trust to provide support can be a great way to make sure that they're taken care of and it doesn't impact their ability to earn government benefits as well. Because again, the trust would own the assets, not the child. So a lot of different trusts out there, a lot of different uses for them. These, again, are some common ones that we have seen. An attorney can help you identify the best uses for you. So this has been, some pretty heavy stuff. It's very serious conversation. How do you talk about this? I do not have a straightforward answer for you for that one. However, what I will say is that your loved ones and your family will be the ones that are most impacted by the decisions that you make. So start early. Talk with your family. Openly discuss spending and money. Openly discuss your family relationships and values and what's important. It's about your legacy and what's important to you and your family. Would you rather avoid the uncomfortable conversations about death and money and leave your heirs in a state of uncertainty? Or do the relationships and peace of mind matter more than the money itself? So talk about it with your family. Staying up to date. Just because you've created a plan, or you're thinking about creating a plan, or you put that will in place 15 years ago, that doesn't mean you're done. This isn't a set it and forget it situation. Estate plans are living and breathing just like you are. So consider reviewing your plan once a year, or if you can't do it once a year, at least a regular basis where you can think about what has changed. Have there been births, deaths, marriages, divorces? Are there any other key factors that have changed in your life that might warrant a change to the estate plan? And lastly, I've mentioned this numerous times now, but you cannot put a price tag on peace of mind. Know that your wishes will be followed when you're gone. You will sleep better at night doing so, and your loved ones will appreciate it more as well. Some resources for you. Contact your advisor at Cutler. Reach out to me, reach out to your advisor. Let us assess your current situation. We're happy to provide attorney recommendations for you. And if you want to do some more research on your own, a couple of great online resources. TheBalance.com has a bunch of great articles on various estate planning topics, as does EstatePlanning.com. And with that said, that's the end of today's presentation. If there are any questions, I would be happy to answer them. Otherwise, please feel free to reach out to me or your advisor at Cutler at any time. Thank you for joining us today.